certificate has been issued. It has been given to Advocate Nisi, his legal representative, Manon. Okay. He will address the court further.
Okay, thanks.
As it is the court, indeed, that's the message. But I took up the situation with him. It was a little discomfort.
Is he okay now?
He indicated that we may proceed, but because...
Maybe it's not okay, we don't proceed. I don't want people to proceed.
No, he is okay,
They say he's not okay, he'll try.
He is okay.
He's okay, okay.
Yes, my lord. But
Fine.
let me just request, because that is got to do with the tummy. So there might be circumstances where we request a short adjournment.
Okay.
But all in all, he indicated that is okay, my lord.
Yeah, one time I was accused. I was doing a case of about 13 accused in Joburg. Then one of the accused, at about tea time, he had some, according to him, stomach cramps and what have you and what have you. And he was rolling there. And then I asked him, can we continue? Then he says, no, he's not feeling well. The state says, no, but this guy may be simulating. So what I did is I said I must phone the district surgeon. Now, the funny thing about the district surgeon, he was busy, blah, blah, blah. So you must get a private practitioner. But then this private practitioner, you must get 3 quotations from 3 private practitioners. And then you choose the lowest.
Yes.
So I had a friend, a doctor who was practicing at the Carlton Center. So I called him to come and attend to this gentleman. Then he attended to him, and he says, no, the gentleman is just stressed because of this case. But otherwise he's okay. The lawyer said, the way I want to convict these guys, I even find him a doctor who will make sure that he attends the case until it ends. Just by the way. Okay, I will continue.
Well, we are
he said he will try.
Yeah.
So we continue with the business of the court.
We can continue, madam.
Okay, fine.
Thank you.
All right. Friday, I said I would make a ruling today. And I want to emphasize, it is a ruling, it is not a judgment. It is a ruling on a point of law. But it also happens to be a constitutional point. When Mr. Baloyi intended to cross-examine Mr. Sibisi using the statement or the confession of Mr. what's his name, accused number 2? Ntanzi. I said to him, is that the correct procedure? Is it admissible? The evidence you're going to adduce. Then Mr. Baloyi addressed me, and thereafter the whole defense team addressed me.
Inkantolo kuyasho ukuthi ngolesihlanu ke wesonto elindlule bekukhona ke udaba la khona umnomzana uBaloyi omele ithimba labashushisi bekaqhamukisa noma bekaveza ke ukuthi akubuzeke imibuzo esotobe mayelana nestatement esenziwa umnomzana wesibili umfoka Ntanzi mayelana nestatement sakhe sokuvuma amacala ukuthi confession ke ngesingisi bese ke inkantolo yabuza ukuthi ngabe kuvumelekile yini lokho ngokwezomthetho bese umnomzana Baloyi wathi yebo watshela bese inkosi yenkantolo ukuthi lokho kuvumeleke kanjani ke bese ngemuva kwalokho nabameli benu nabo bonkana bakhuluma bese batshela inkantolo ukuthi lokho kuvumeleke mhlawumbe kuvumelekile ngendlela ekanjani.
Yeah. So I researched a bit and I found the case of Mhlongo. I think it is applicable here because in the Constitutional Court, in that appeal, the defense raised two constitutional issues that the circumstances surrounding the cross-examination of that of those two accused was not fair because it transgressed or contravened Section 9 of the Constitution, which guarantees that an accused should be accorded, or all accused in a trial, even the witnesses of the state, should be accorded fairness. They mustn't be treated unequally.
Bese cacaphuna ke inkantolo kwicala likaMhlongo kade lihlelelwe ngaphansi kwenkantolo yase Supreme Court of Appeal bathi lapho khona isigaba somthetho saka section 9 mhlambe isigaba somthetho saka 9 la bathi inkosi inkantolo ithi abameli becala licala likaMhlongo kukhona umbiko abawuveza ukuthi lokho kwenzeka kade kwenzeka ngendlela engekho semthethweni okahle bese wathi bathi abameli licala kaMhlongo kwamele ukuthi abasolwa bonkana basecaleni baphathwe ngendlela efanayo noma ejwayelekile.
And further, that Section 35F of the Constitution was being transgressed because it deprives accused number 2 the unfettered right to give evidence. We must remember he hasn't given evidence. And he also has the right to challenge evidence, even the evidence, if he wants to, of accused number 1. So that right remains unfettered. And what has happened in this case, Mr. Baloyi has already cross-examined accused number 1 regarding the so-called confession or extracurricular statement he made. And this court, you'll recall, all I did was to make a ruling that the statement or made by Mr. Sibisi. Is it Sibisi? Sibia.
Sibia.
Sorry, I'm sorry. It's not, the status of that statement has not been defined, definitively defined by this court as a confession or as an extracurricular statement. Mr. Baloyi calls it an executive statement. Because what has happened is, normally a confession, State versus Bartman, I think 1929, defines it as an unequivocal admission of guilt. But if you look at the statements made by Mr. Sibia and Mr. Ntanzi, they are not unequivocal admissions of guilt. An unequivocal admission of guilt is where a person makes a statement and admits all the elements of the offense. Like saying, I killed Ratha and burned his body. But in this matter, which we are having, we have not yet, as I say, made a definitive statement to the status of the statements, what they are as from the court's perspective. This very issue was transgressed and debated in the case of Oswald John Mhlongo and the state, and Alfred Disco Nkosi and the state. I'll just read the law as expounded by the Constitutional Court. Equality before the law, that is Section 9 of the Constitution. It was contended by the applicants that the distinction drawn by Ndlovu between admissions and confessions effectively leads to indirect differential treatment between groups of accused persons. Those implicated by an admission on the one hand and a confession on the other. A confession is inadmissible against another person, while according to Ndlovu, an admission may be admissible. We all know that Ndlovu was set aside. It violates Section 9(1) of the Constitution, which provides that everyone is equal before the law and entitled to equal protection and benefit of the law. The distinction between the confession and admissions is determined solely by the extent to which the statement implicates its maker. This distinction becomes relevant in determining the safeguards that are put in place to ensure the voluntariness of the confession or admission. If a confession can be used with little more to secure the conviction of its maker, as opposed to an admission which would still require the state to prove various elements of the crime, then there may be logic in applying more stringent requirements on its admission against that accused. The distinction apparent in the difference between Section 217 and 219A of the current CPA, however, the distinction has nothing to do with a third party. Accordingly, there is no rational reason why, when used against another person, there should be a difference in the admissibility of the two types of statement. The Supreme Court of Appeal in the case of Ditako said the following: from the perspective of one accused who may be implicated in the statement of another, one strains to discern a sound jurisprudential basis for the distinction. While the court in Mulimi declined to pronounce on the issue, it did state that the argument may be sound. The differentiation must be evaluated in terms of Section 9(1) of the Constitution. This court has held that a distinction made in the law will contravene Section 9 if it is irrational. The purpose of this is to ensure that the state functions in a rational manner in order to enhance the coherence and integrity of the law. This is essential to the rule of law, the fundamental premise of the constitutional state. It must be ascertained whether the differentiation complained of is rationally connected to the achievement of a legitimate government purpose as opposed to being arbitrary or capricious. To this end, a legitimate purpose must be identified. It is difficult to conceive of any rational reason why an admission ought to be admissible against a co-accused, but not a confession. The state offered no reasons in this differentiation. The rationale for precluding the admissibility of a confession, the inherent dangers in using statements by co-accused, which is expressly guaranteed in Section 219 of the current CPA, applies equally to admissions. Ditako expressed concern that the mere characterization of a statement as a confession or admission could determine its admissibility. It has not been done here by this court. That concern became manifest in this matter. The High Court initially characterized the extracurricular statement by Mr. Macheke and Mr. Kanye as confessions, only to later recharacterize them as admissions. It was contended by the applicants that this was an attempt to force open the door to the admission of these statements as evidence against them, and that this could undermine the integrity of the courts. Even though admissions and confessions are distinctly defined, it is possible for courts to get it wrong with possible prejudicial consequences for an accused. The differentiation between the accused implicated by confession versus admissions cannot be lawfully sustained. It is not designed to achieve any legitimate purpose. It is an irrational distinction which violates Section 9(1). It cannot be saved by the limitation clause contained in Section 36 of the Constitution, because this limitation of the right to equality before the law is not reasonable, justifiable in an open and democratic society based on human dignity, equality, and freedom. Nor did the state seek to justify this limitation. Right, so that is the reason this court said maybe it would be infringing on the rights of accused number 2 to use number 2's statement or confession to cross-examine Mr. Sibiya.
Befunda ke inkosi inkantolo kumanye ke amacala selahlalwa ngaphansi kwenkantolo ephakeme se-Supreme Court of Appeal kwicala lika Nkosi nebheno umbuso ke lapho bekhuluma khona ke ngodaba lwama-admissions futhi ngodaba lwama-confessions ukuthi lokhu kumele ukuthi kusetshenziswe kanjani mhlawumbe kwenziwe kanjani ke la bekanza isibonelo uma icaphuna ngaphakathi kodaba olakhulunywa kwenkantolo mhlawumbe kwicala leli selahlalwa ngaphambi kwenkantolo esikhathini esindlule laba khona khona ngodaba ukuthi ama-confession nama-admissions izinto ezinjani futhi uma ukuthi zehlulwe kanjani ke phakathi kwazo uma ngabe sesetshenziswa futhi bese inkantolo yasho ukuthi lapho ke la ngaphakathi kwenkantolo esikuyona njengamanje ke lolu daba lama-confession amadaba lama-admissions lusengakafiki ngaphambi kwenkantolo ukuthi inkantolo ekwamukele noma mhlawumbe ke yamukele itatimende lezo ke bese futhi yasho ukuthi lokho ngeke kube yinto elungile noma mhlawumbe kube kunqasha amalungelo akho ke umnumzana uNtanzi ukuthi athathe istatement sakhe ke bese babuze ke umnumzana uSibiya mayelana naso.
All right, the common law exception. At common law, there is an exception to the exclusion of extracurricular statements of co-accused if the statement constitutes an executive statement by an accused. This court has not made a finding that the statements of any of the accused, 1 or 2, are executive statements. Persons or people must remember that this case is still continuing. That election will be done by this court at the end of the case, after all the parties have addressed the law, the facts. But at this moment, this court is still continuing. Only one accused person has given evidence, although he has not yet completed his evidence. So that's the reason I say I'm not interpreting the law. I'm just saying this court has not as yet said any of the statements here of either 1 or 2 constitute an executive statement that is by an accused. It may be admissible against a co-accused if it was made in furtherance of a common purpose or conspiracy. This court has also not made a finding as to whether all these accused before court acted in pursuance of a conspiracy or a common purpose.
Iyaphinda futhi yasho ke inkantolo ukuthi malana nodaba leyitatimende lezi ezenziwe mhlawumbe abatheka ithimba labashushisi zikhona umsula oqala abazenza futhi umsula wesibili wazenza ke isengakafiki esimeni sokuthi ithathe inqumo zokuthi kuyasamkela ukuthi vele lokhu nakwenza ke noma mhlawumbe nakhakhe uzungu mhlawumbe nakhakhe itulo ekuthizeni enzeke icala le futhi yasho khona njathi lokho isinqumo sayo izofika kusona ke emaphethelweni ecala uma ngaba nonkana senisele nethule ufakazi benu okwamanje ke nisakaqina nawe usangaqedwa uthula ufakazi futhi kuzofika kuze kufike esigabeni sasasa manje uwe kuphela osoqalile ukuthula ufakazi bakho ke futhi abafowethu abanye basangaqala ukuthi bathule ufakazi babo.
Right, there must be other evidence aliunde to establish the existence of a common purpose before the statement can be taken into account. This court has not pronounced on the evidence aliunde. This court may have pronounced on the application lodged by by accused number 4's counsel when he was bringing an application, that is Mr. Mapisa, when he was bringing an application on behalf of Mr. Mapisa, all the court pronounced upon was that the evidence of Zungu was not so hopeless that it can be thrown away.
Futhi aphinde inkantolo yenze isibonelo ukuthi umuntu obalithe isicelo kuphela phambi kwenkantolo sokudedelweke umnumzana uMaphisa kade kumnumzana uNqumalo omeleke umyena kumnumzana uMaphisa ngesikhathi bathe isicelo saye sokuthi umnumzana inkantolo udedelwe umnumzana uMaphisa ngaphansi kwesigaba sezomthetho saka 174 bese kathi inkosi enkantolo lapha yana ngaphansi kwesicelo esikade silethile wasebenzisa kufakazi bakaZungu ngoba kade kuyibo ufakazi bakaZungu kade bumbeka ngaphakathi nendawo.
And that is the only attack Mr. Nqumalo made in that application for 174. And I opined that there's other derivative and constructive evidence which was led in this court. For instance, I said, there was evidence pertaining to cell phones, etc., etc. So this court never pronounced itself on the other evidence which Mr. Nqumalo ignored. And I said the case against the accused is not only predicated only and solely on the evidence of Zungu.
Futhi yasho ukuthi inkantolo ngesikhathi umnumzana uNqumalo balethe isicelo sokuthi inkosi enkantolo mhlawumbe inkantolo dedeleke umnumzana uMaphisa emacaleni wonkana wamthusa wonake umnumzana uMaphisa udaba kade alisebenzisa kakhulu kumayelana nofakazi bakamnumzana kaUzungu kepha lokho kukhona olunye ke udaba umnumzana uNqumalo angakaza alisebenzise ngesikhathi kade lethake isicelo sokuthi inkantolo dedele kuMaphisa emacaleni kade ethusa wona wonkana umnumzana uMaphisa ufana ukuthi udaba lozama cellphone futhi nokunye.
Consequently, that's why I say there's merit by the defense to say that at this juncture, there is constitutional invalidity regarding Mr. Baloyi's attempt to take the statement of accused number 2, who has not yet cross-examined Mr. Baloyi, Mr. Sibiya, and that is frowned upon by section 9(1), and consequently also it infringes section 35 of the Constitution regarding the freedom of a litigant or an accused person to give evidence and attack the evidence of a co-accused if he so desires. Consequently then, the ruling I made against Mr. Baloyi stands that he cannot use the statement of accused number 2 to cross-examine accused number 1 because of the experiences which I have mentioned, that no pronouncements have been made regarding the status of the statements or confessions or pointing outs. The case is still ongoing. Okay.
Manje isinqumo senkantolo inkantolo iyanqaba ukuthi umnumzana uBaloyi aqhubeke. Isinqumo senkantolo sithi ke inkantolo iyanqaba ukuthi umnumzana uBaloyi aqhubeka kuze ke imibuzo phecelezi mamelana nodaba statement sakamnumzana uMaphisa umnumzana uNtanzi asenza ke isilungiso lapho malana nestatement umnumzana uNtanzi azenza ngoba lokho kushuthi lapho ucekela amalungelo akhe ezomthetho phansi kumnumzana uNtanzi futhi akuvumelekile ngaphansi kwesigaba sezomthetho saka 91 futhi nesigaba sezomthetho saka 35 futhi yasho khona njalo ukuthi ngoba wena ke uqala useqalile ukuthi uthula ufakazi bakho futhi umnumzana uNtanzi usayakafike nesigabeni sokuthi ezela ngaphansi kwebhokisi bese thula ufakazi bakhe.
Yes, Mr. Baloyi.
As a court, please, my lord.